Hi, everyone. Thank you so much for joining us today. We're going to give folks just a minute or two to tune in before we begin our program. But I just want to start by thanking Justice Earls and Justice Riggs for being with us today. How are you both doing?
Wonderful. Thank you.
Yeah, doing well, thanks.
Great to hear. How's the weather in North Carolina?
Well, it was a bit dark and stormy a little earlier, but now the sun has come out, so.
It was I think we hit 93 degrees yesterday, so it was warm, but the rain's cooled us off a bit.
Honestly, the heat sounds lovely. I'm in Michigan, and there were 11 tornadoes in Michigan the other day, so that's not too typical of our spring weather. Hopefully we'll be through the stormy stuff soon and just into the warm as well. Just give folks about one more minute and then we'll get started. Okay, I think we can go ahead and get started. Good afternoon to everyone joining us, and thank you all so much for being here. My name is Erin Butler. I'm a Regional State Courts Counsel for Alliance for Justice Action campaign. AFJ Action believes that our rights are only as good as the people who interpret them. We engage the public to fight for justices who will protect the rights of all of us and not just the wealthy and powerful. Today's conversation is our inaugural event in the series Gavel featuring judges, leading activists, scholars, and attorneys to discuss current political and social justice issues. Before we get started, I wanted to note that Zachery Morris, our legal director of state courts, had originally planned to moderate this event. However, he is unfortunately under the weather and asked me to pass along his apologies for having to miss today's conversation, as he really was looking forward to speaking with you both. So we do hope that he's feeling better soon, and we can go ahead and get started. I'm so grateful to have Justice Anita Earls and Justice Allison Riggs, both of whom are associate justices on the North Carolina Supreme Court, here with me today. Prior to her time on the bench, Justice Earls was an experienced litigator at the state and federal level on criminal defense, personal injury, voting rights, police misconduct, school desegregation, and employment discrimination cases. In 2007, Justice Earls founded the Southern Coalition for Social Justice, a nonprofit legal advocacy organization, and she served as its executive director for 10 years. She has served as an associate justice on the North Carolina Supreme Court since 2019. And Justice Riggs has been an associate justice of the North Carolina Supreme Court since 2023. She previously served as a judge on the North Carolina Court of Appeals. And prior to joining the bench, she was the co-executive director and chief counsel for voting rights at the Southern Coalition for Social Justice. Justice Riggs is a civil rights litigator and community lawyer who has served as lead counsel in numerous voting rights cases, including twice arguing before the United States Supreme Court. Justice Earls, Justice Riggs, thank you so much for being here today. We're so honored to have you here with us. And just a couple of quick housekeeping notes before we get started. Just a reminder to everyone listening that this is a conversation on the importance of state Supreme Courts and not an endorsement of any candidate or candidate committees. And I also wanted to let listeners know that at the end of our discussion, we will have some time for audience Q&A. So please submit questions where you are watching the broadcast. So for instance, if you're watching on YouTube, submit your questions in the YouTube comment section. So let's go ahead and dive in. So once again, welcome to you both. And for people unfamiliar with the North Carolina court system, can you just take a couple of minutes to explain how a case challenging a law impacting the franchise, such as a voter ID law, for example, gets to the North Carolina Supreme Court to be heard by you guys?
Sure. Well, I'll jump in. So we are a 7-member Supreme Court elected in partisan elections. We have an intermediate Court of Appeals, 15 members. They sit in panels of 3. Our court hears every case, all 7 of us. So to get to our court, a case would be filed in a trial level court, typically Superior Court. And then depending on how the case is resolved, either that is before trial at summary judgment, or after there's a trial where a trial judge determines the facts, the parties can appeal to the Court of Appeals. They can also ask us to directly, us being the state Supreme Court, they can ask us to bypass the Court of Appeals, which is not uncommon, I would say, in election law cases, because there's always an election coming up and people want their election law disputes decided before the next election. So either the Court of Appeals hears an appeal first, and then the parties can ask us to take the case. And I'll just note there's a change in how cases get to us, which I think is significant. But the parties a case can be heard at the Court of Appeals, so the parties can ask our court to review the legal issues, and then it takes a vote of 3 members of our court on certain types of petitions. Other types of petitions, it takes 4 members of our court to agree now to hear the case. And that's what's different. Our intermediate court was established in 1967. And since that date, there has always been, in our state, an automatic right of appeal to our court from the intermediate court if there's a dissent. Remember I said there's 3 judges who hear the case. Well, if one of the judges dissents from what the other 2 have held, there's an automatic right for the losing party to come to our court if they wish. That existed until the General Assembly in a budget bill included a provision to eliminate that. So that no longer exists. So going forward, a case gets to our court only if our court agrees to hear it. And the other thing I'll note is just, if you're challenging the constitutionality of a state statute, there's a state law that says if you're challenging it as applied, so not saying the entire law is unconstitutional in every possible circumstance, but if you're saying as it applies to me, the law is unconstitutional, then the trial can be had with a single judge. But if you're saying the law as a whole is unconstitutional and shouldn't be applied to anyone, then that's a facial challenge, and it has to be heard by a panel of 3 trial court judges, and that panel is appointed by the Chief Justice of the Supreme Court. So where you start out to begin with, whether it's a single judge or 3 judges, depends on the nature of the constitutional challenge that you're bringing to the law.
And the only thing I would add to that for folks listening is just understanding that some of these changes about having that 3-judge panel for facial challenges is a relatively new development in North Carolina law. So the legislature makes changes in a regular manner to how people litigate in front of our state courts cases involving the franchise. So both Justice Earls and I have litigated voting rights cases that were heard in front of single judges before the change and I've litigated ones in front of 3-judge panels after the change in the law. So I think that's a dynamic aspect of our state judiciary that folks should know about.
Okay, so it sounds like a lot of different ways that cases can be heard before your court. Can you tell us a little bit about how the North Carolina Supreme Court has shaped voting rights and access to the ballot in your state?
Yeah, Justice Earls, do you want me to Get started. Okay, so our state constitution has been a critical part in understanding access to the franchise and how advocates have fought for access to the franchise for redistricting and for just general ballot access rules. So we have a constitution that contains provisions governing how state legislative redistricting, and for folks who don't necessarily spend a lot of time on redistricting is the drawing of electoral boundaries after a census, usually to even out the population and to just change the lines that are used to elect to different levels of government, from town councils all the way up to our Congress. When Justice Earls and I started practicing, a front of the state constitution's impact on voting rights was around this whole county provision and how it would impact state legislative redistricting. This was also, there have been lots of cases under the federal constitution around racial gerrymandering and partisan gerrymandering, but our state constitution has been and is an important font of rights when it comes to redistricting. Over the years, we have used, when I say we, I was using that as when I was an advocate, now I'm on the bench, but advocates used our state constitution, its unique provisions like our free elections clause, to argue for more fulsome rights than are provided for voters by the federal constitution. And so that showed up in fighting against ID laws that were being photo ID laws that were being challenged as discriminatory. It showed up in challenges against redistricting plans that were alleged to be extreme partisan gerrymanders. And, especially I would say in the court, as it existed in 2022, we saw the state constitution being a very powerful tool to protect the right to vote. So the North Carolina Supreme Court, before I joined, struck down extreme partisan gerrymandering as unconstitutional under our state constitution. Under numerous provisions, our state equal protection clause, our freedom of assembly and association clauses, our free elections clause, our state Supreme Court upheld the trial court's findings of fact and conclusion that a voter ID law was intentionally racially discriminatory. And so those are some of the ways in recent years we've seen our state constitution really playing an important role with respect to the franchise. Would be remiss to say those two decisions that I just discussed were reheard and reversed last year by the North Carolina Supreme Court after the 22 election, when its composition changed before I joined the court. So that's just a highlight. Justice Earls has much more to add, I'm sure.
Well, I'll just point out that it's not a new development, that advocates seeking to vindicate the right to vote in the state have used state courts, even as around things like, so the state constitution actually still has a literacy test in it, a literacy requirement to vote. It's no longer enforced, but there were challenges to the literacy test brought in state court. In the 1970s, there was litigation that made it to the state Supreme Court over students being able to vote. And could students vote in the county where they're going to school, or did they have to vote where their parents lived? And so throughout time, basically, like the state courts and North Carolina Supreme Court has dealt with issues both around access to the ballot, as well as how the state constitution should be interpreted around redistricting. And I'll just point out that there's actually quite a tradition of our state court saying that the equal protection clause of the state constitution provides greater protection in the voting arena than the federal equal protection clause. So, for example, our state court decided that judicial districts, so for our trial level judges, they are elected from districts. The appellate judges are all elected statewide, but the trial level judges are elected from districts. And we have an opinion that says those districts have to be the same size. They have to meet the one person, one vote requirement. Whereas federal courts have said that under the federal constitution, because judges are not representatives in the same way that legislators are, that judicial districts don't have to be the same size, don't have to meet the one person, one vote requirement. We've also said that our state equal protection clause prohibits the use of single member and multi-member districts in the same districting plan. So again, historically, we used to have state legislatures where some people would be in a single member district and they would elect one legislator, and other districts would elect 3 or 4. Typically the urban areas would elect 3 or 4 state legislators. And our state Supreme Court said you can't do that under the state constitution. We have also found a compactness requirement under the state constitution. So there's actually a tradition in this state of looking to the state equal protection clause and to the state constitution to provide greater protections than are found in the federal jurisprudence, federal law.
Great, thank you, both of you. And going back to something that you mentioned, Justice Riggs, the court recently reheard and redecided the Moore v. Harper and Holmes v. Moore decisions in 2023 after previously ruling on them in 2022. Do state Supreme Courts typically rehear cases that they had delivered decisions on in previous terms?
So Justice Earls did
and that can be for either of you as well.
Justice Earls did the research on this, but in North Carolina, it is exceedingly rare that we rehear cases like that, and to rehear them on those kinds of matters in sort of bulked together is really unprecedented. I think Justice Earls had some statistics in her dissent to the decision to rehear those cases.
Well, the point that I make in the dissent is that we've never done that. We've never reheard a case in order to reverse it. If there's a factual error or some kind of very clear mistake in an opinion, there have been rehearings allowed. If there's an unintended consequence that no one on the court thought of at the time, but to rehear the same case after it's been decided, to reverse it, because, and the other link to make here is this is after an election, after the personnel on the court have changed. So prior in 2022, we had a court that was 4 Democrats, 3 Republicans. After the election is a court of 5 Republicans, 2 Democrats. And it was after the election that the court agreed to rehear the case. And what I'll say about why that's extraordinary is both because of this concept of stare decisis in our law. That is, once you've decided something, it should remain that way, because that's how you guarantee equal justice under the law, right? You apply the same law and the same legal rules to every case that comes before you. You don't switch and change the law just because the court has changed, just because the members of the court have changed. But secondly, there's a principle called law of the case, where if you've got a legal principle that an appellate court has established in a case, it's not supposed to change midway. And I think that's actually the logic behind that principle. Like, why don't we change the law in the middle of litigating a particular case? The logic behind that is especially illustrated in the voter ID case, because in that case, the trial court, the litigants argued that the issue in the voter ID case was, is the voter ID law intentionally racially discriminatory under the state constitution? The litigants argued that the standard, how you prove intentional racial discrimination, is determined by a long-standing case from the U.S. Supreme Court called Arlington Heights. And so that's the legal criteria that the trial court applied. The plaintiffs marshaled their facts to meet those elements. And then on review, our job is actually, we're supposed to take the facts as they were found by the trial court. We don't hear witness testimony. We don't, review the evidence and decide what was right and what was wrong. The facts are decided at the trial level. We're just supposed to look at it. Did they get the law right? And did they apply the law properly to the facts? And so the first time the court heard the case, that's what we did. We said, yes, these are the Arlington Heights factors. This is how you prove intentional racial discrimination. And we're going to apply that to the facts that the trial court found after hearing testimony, after having the evidence presented to it. Then when our court decided to rehear the case, reopen the same case, they said, we're not going to use the Arlington Heights standard anymore. We think that that's too easy to prove intentional racial discrimination. So while it might be that standard in federal law, we're going to have a different standard under our state constitution that makes it much harder to prove racial discrimination. And the plaintiffs didn't prove it, so therefore the law is fine. And if the plaintiffs had known that there was going to be this other standard, they might have presented different evidence. The trial court might have analyzed it differently. But rather than remand the case and let the parties use the new legal standard, our court said, well, applying the standard, they lose. And I think that illustrates why we have this principle that once a court has said what the law is in a particular case, it's supposed to stay that way to resolve the case.
Right. Thank you so much for that, Justice. I just wanted to take a really quick second to remind our audience to submit your questions for the justices in the chat for our Q&A portion. It's coming up a little bit later. So how can we ensure that state Supreme Courts remain independent, equal checks on the other governmental branches as our founders intended, and avoid being labeled judicial activists when these decisions that check the power of other governmental branches are made?
Well, I'll just say, I think the public is beginning to understand that judicial activism is just a label that the losing side uses when they don't like how the court has ruled. I hope that people appreciate that term has just become incredibly politicized. I think a bigger answer to the fundamental question you're getting at is how do we end up with state courts that are fair and impartial? And a lot of it is very state specific. There's a wide variety of ways that state courts are composed. Some are only 5 members, some are 9 members, some are appointed, some have retention elections. I honestly think that while the focus on how people are selected to go on the court is valuable, and we can have lots of public policy discussions about which is the best way, at the end of the day, whether or not you have a state judiciary that is living up to the values and the ideals of a fair, impartial, independent judiciary rests with the integrity of the people who sit on the court and the other political actors in the system. And so I would say that, and again, this is very context specific. So other state courts have other issues. I can imagine a scenario where the financing of political campaigns could emerge as the biggest threat to judicial independence. There's certainly, you can point to some historical examples where there was a sense that a particular candidate for a state Supreme Court got so much money from a single litigant who was appearing before them that caused there to be questions about whether that justice was being independent. But I think from my experience on our court, the biggest threat to judicial independence in our state really has been the legislature and the political culture. And so I kind of want to say, if you want to fix our courts, you have to fix our politics. And maybe that's good news, because all voters have a role in fixing our politics. And vote ultimately, I strongly believe that ultimately addressing these issues is in the hands of voters, and that's both a responsibility, but also a burden to follow what's happening with your state courts and be ready to pay attention to in states where justices are elected. And I think Wisconsin is a great example of another state court where there's been a lot of attention to state court elections and the implications of those elections for people's lives. And I think more broadly, there's an understanding that state courts make some really important decisions, not only about voting, but about women's reproductive health and about the environment and about, the treatment of racial minorities. So there's like a wide range of ways in which state courts are really impacting people's lives. And in states where the courts are elected, the voters really have a key role to play.
Yeah, I think for good reason, we have wanted the judiciary to be the branch that was a little bit more politically insulated from political pressures, whether or not we're there in various states. Like Justice Earls said, I agree. We're in a state in North Carolina where actors external to the judiciary have taken actions that have undermined the public's perception, I'm hearing, in the integrity of the courts. And so what I think a lot of the listeners here can do, in whether it's North Carolina, their home states, or from their vantage point, is, we have to shy away from a tendency to not want to hold judges accountable either. Obviously, it looks different in different states, depending on whether or not you have retention elections or not. But still, there is a principle of, if you are electing judges, and not applicable in states where they're appointed, but if you are electing judges, then it is the people's decision whether or not to keep those judges serving. And those voters are entitled to hear about and be educated about our decisions and our values and our background, so that they can make an informed, empowered decision and decide who they want on that bench, setting the tone for how the courts work from the Supreme Court down to the trial courts, and who they want being the ultimate arbiter of a state constitution that, in a national atmosphere of where we're seeing a lot of our federal freedoms, what were previously recognized as federal rights, being rolled back, whether the state constitutions still stand as that important front of protecting personal liberties and freedoms that way. And so I think when we do voter education and voter engagement, really prioritizing transparency and accountability, even in judicial elections, is ultimately, if we're going to elect judges, it's critical that we do that.
Thank you so much for that from both of you. So after the 2020 presidential election, sort of in the backdrop of challenges to presidential election results in several states, election administrators and state court judges who are working to uphold election results were heavily targeted and attacked. We're anticipating that state courts will likely play a crucial role in our elections again in 2024. So can you talk about some challenges for state courts and others as they take on that active role in protecting our democracy? What are some implications for the safety of judges with threats like some of those that we saw in 2020 being launched against them?
You know, whether it's the people who are staffing polling places, administering elections, or in some kind of elected or appointed public service office, I think we engage in all forms and levels of public service because we believe in the value of running our democracy according to our ideals and aspirations, and with that comes some risk of being public officials. I'm cognizant. I'm newer to this role. I've been on the bench now for about 16 months, and there are. I have seen some of the risks already bear out. When you're a public official, accountability is good, hate is bad, and you do get subjected to some of that hate mail and threats. But at the end of the day, I think we can continue to improve systems for security, but I can't do my job if I sort of worry too much about, it doesn't mean I don't take every safety precaution, but if my willingness to stand up for the Constitution, to enforce the guarantees of the Constitution when it comes to our democratic processes, if that results in some sort of problem like we saw on January 6th in Washington, D.C. Like, I can't live in fear of that, because what is at stake is too great. And I think, this is what the people of the state are asking us to do, is stand strong in our constitutional convictions without fear or favor, meaning I'm not favoring any side, or I'm not scared of any side who comes in front of me. And also, I'm going to decide the law based on what I believe is required, not because of, what critiques, criticisms, even inappropriate ones I may face afterwards. So the flip side of the what I just said about accountability is I have to be willing to be held accountable, and I am. And I think that the last thing we need is for people on the bench who are too worried about that and not as worried about being the independent and powerful separate branch of government that we are supposed to be.
So I served on the North Carolina State Board of Elections for, I think it was about 2.5 years. But between, I think it may have been sort of 2010 to 2012. So in a different era politically, for sure. But so some of my answers informed by that experience. And I guess the other way in which my answer to your question is going to be informed by my experiences. I honestly can say that in the 30 years that I did voting rights work, I was always doing that work in a nonpartisan fashion. Even when I was at the U.S. Department of Justice Civil Rights Division as a political appointee, right? At that time, President Clinton appointed me to that role. And one of the sections I had was the voting section, but we didn't. If we got a report of someone being harassed at the polls or being intimidated from voting, or even more systemic concerns about elections at the Civil Rights Division, our responsibility was to make sure that the Voting Rights Act was enforced, that minority voters, racial minority voters, language minority voters, Native American voters, that they all had an equal opportunity to participate. We didn't ask what party they belonged to. We didn't ask, are they voting for Republicans or Democrats? So I've always been in a situation where my commitment to voting rights has been across the board, that every voter should have the right to vote and all those votes should count equally. So when I look forward to, when I think about what might happen in the fall in terms of the way in which the integrity of our election process is being challenged, we've read in the papers here in North Carolina the incredible stress right now that our local boards of elections are feeling under, and it's not only because of the lack of confidence in their work. But also because there's like so many new laws that they're supposed to be, there's just been like, I feel like there's just been an explosion of new laws about the elections process, that they have to train their folks. And when you think about this army of temporary workers, like it's even more, to me, it's like even a bigger task than Christmas help at the department store, right? There's this army of people who have to go out and be the precinct chairs and, you know, check you in when you go to vote. So they have to train all those folks, and it's an incredibly difficult job that's under-resourced financially, and yet it depends on the trust of the public. And so at the end of the day, I think part of what we all can do is either like you can volunteer to do that yourself, like be a poll, like work at the polls for your local elections board and have the courage to be a part of the elections machinery, but also to truly be responsible citizens. And so responsible citizens means that you educate yourself about who's on the ballot and you go and cast your vote. But it also means that you don't buy into false allegations of voter fraud or problems at the polls or some reason why our election isn't legitimate, while at the same time, you know, if there are actual problems, like, you know, if a poll, there are reports of people being intimidated on election day, people with guns walking around in front of a polling place, or video recording people as they go in and come out of the polling places, which in rural areas, particularly in the South, has been a means of intimidating folks, because it's certainly in the memories of some of my clients that voting was a dangerous thing. You know, in other words, so African Americans in the South prior to, let's say, 1970, could be fired from their jobs or otherwise harassed or intimidated if they tried to vote. And so those kinds of intimidation tactics, like, we have to be ready to stand up and say that has no place in our democracy. But we simultaneously have to be able to weed out and not pay any attention to false claims about tampering or fraud. And I think we can continue to find and lift up those examples of people with integrity who are willing to stand up for our elections process. And I'm actually thinking of a judicial example. Prior to the election of 2016, the General Assembly passed a law in North Carolina that would say if you're already on the Supreme Court, North Carolina Supreme Court, that there would be retention elections. So voters could vote to keep you or not keep you, but no one could run against you. So it was changing the election method. And there was a lawsuit brought to say that was unconstitutional, that that's not an election under the meaning of our state constitution. And at the time, there was one member of the state Supreme Court who was up for election, a Republican, Justice Edmonds, and he recused from that case. He said, I should not decide this case. And he did that knowing that the result of that would be that law would be considered unconstitutional, because the Court of Appeals, but remember we talked about that intermediate level court, the Court of Appeals had already ruled and said this is unconstitutional. Where you have elections in North Carolina, you can't convert them by statute into retention elections. And with the court then being split 3-3, the Court of Appeals opinion remained as the final say. And so he had to run in a contested election, and as it turned out, he lost. But he had the integrity to say that as someone whose seat is impacted, I shouldn't be ruling on this case. And so, to me, that is the kind of public official who is in a position of power, but who lives up to the principles of fair. Like, there was nothing would have happened to him if he had said, I want to rule on this case. Like, there was no authority that could have impacted him. But he took it upon himself to do the fair and take the step that would most promote faith and confidence in our judiciary. And that's what we need from our leadership at every level. You know, whether you are your local board of elections appointee or whatever role you have in public service, to stand up for the importance of the institution and the importance of your role serving the people. I think if we highlight that and celebrate that and encourage people, hold people to that standard, that we'll get back to having a democratic process that we in this country can be proud of.
All right, thank you both so much. I'm gonna go ahead and move it into the audience Q&A portion of the discussion now. Our first question, other than people's rights and ability to vote, how else would you say that state Supreme Courts impact people's everyday lives?
So in particular in North Carolina, our Chief Justice, an elected position, our Chief Justice sets a lot of the policies and practices that that govern our entire judicial system. So our state Supreme Court Chief Justice can decide to embrace diversity, equity, inclusion, like Chief Justice Beasley did in establishing policies and practices that our trial courts would employ, that court staff would employ. If you think about the ways in which people who have had a negative interaction with the justice system, criminal or civil, have interacted with the justice system, it matters the training and the way in which security at the front of the courthouse interacts with the people coming into the courthouse. And so we can either embrace making our justice system truly responsive, attentive to implicit bias and to the historical and continuing discrimination that marginalized communities feel, or we cannot. So when I say what is at stake when you vote for your state Supreme Courts, and sometimes that's decided by the Chief Justice, like it is in North Carolina. Sometimes the entire court may be weighing in on these things. Sometimes you may have different accountability people, but in North Carolina, folks should know that if we want to address inequity and injustice in our justice system at every level of government, our state Supreme Court elections, in particular our Chief Justice election, but these are really important. It's much bigger than just interpreting statutes or the Constitution. It's the day-to-day mechanics of our court system. And I personally think that we should be leaning into our obligation as jurists, and particularly at the top of the judicial system, working to address racial inequities and socioeconomic inequities in our justice system. So that's at stake.
I would say there are a number of really important ways that our court impacts people's daily lives. So if you are injured at work or in a car accident, or if you need medical treatment and you get significantly substandard medical treatment, are you going to be able to be compensated for those types of injuries? That's something that our court decides. If you have a dispute with your employer, if you get fired and you believe that it was because of discrimination, there are a number of ways in which our court makes decisions that impact that. If you buy your home and the bank, somehow doesn't credit your mortgage payments, our bank makes decisions about that. I mean, our court makes decisions about whether the bank is right or you're right. Disputes over property, disputes over everything that happens in family law. So divorces, child custody, when children are neglected and abused. Decisions made by our court. And in family law, I think in particular, we see where there's a lot of sort of cultural assumptions that then enter into the court's decisions. So really, to my mind, really important that we have a diverse bench that represents the full diversity of the people of this state when we're making decisions about family law. The environment is the state authorities that are supposed to protect your water and clean air, are they going to be empowered to carry out their regulatory functions? Or is our court going to allow businesses to contaminate your water? Similar issue about Duke Power. If Duke Power has created these coal ash deposits that then seep into our water, who has to pay for that cleanup? Will Duke Power shareholders pay for it, or will the utility consumers, i.e., everybody who buys electricity for their home, are they going to pay for it? So everything from your light bill to what happens in a divorce to if you get in a car accident, all of those types of things are decided ultimately by our court in ways that significantly impact people's lives.
Thank you both so much. Our next audience member question. So as we know, when you are writing a dissenting opinion, your opinion is in the minority of the court. So, but how can dissents contribute to the preservation of constitutional principles and individual rights and potentially safeguard against the erosion of our fundamental rights in the face of a prevailing majority opinion?
Well, I'll just say that to some degree, we don't have control over that. I believe, and I say this to myself all the time, the voters elected me to give my views on the law, not my views on my colleagues. So the purpose and point of a dissent is to say what I think the law is and how I think the majority got it wrong. What happens after that will depend on future litigants. And I really want to emphasize this. I think the people, you asked earlier, how does a case get to our court? And I forgot to mention that a case only gets to our court if there's a plaintiff willing to stand up and put their name on a lawsuit and engage in the really challenging effort that it takes to litigate a case, and especially a civil rights case. So it takes someone being willing to be a plaintiff, and it takes lawyers who are truly gatekeepers. Lawyers decide which cases are going to get heard and which ones won't, because if no lawyer is going to represent you, you're really going to have a hard time. I think actually more people than not are unrepresented in our courts for one reason or another. So that's a whole other equal access to justice issue, that the lack of affordable legal services for the majority of people in our state. But apart from that, it's the lawyers who decide whether or not you've got a case and whether or not they're going to file a lawsuit. And they're the ones who shape the case. What evidence is relevant? What legal theories are they going to bring? What claims are they going to assert on your behalf? So the lawyers are really important, and what happens to our dissents will depend on what the lawyers do in the future. You can certainly trace a lot of current majority opinions from past dissents, and that works both ways. So the current majority is writing opinions that are based on dissents that they wrote when they were in the minority. I mean, that is just happening in our court. So it's it really depends on what folks do after we issue those dissents. But I will also say, it's not something that I do lightly. But if I think that the majority, and about at least half our cases are unanimous, so we don't dissent every single time. But when it's important, I do try to give my view of what the law should be.
Erin, if you want to get to one more question, I'm fine, or I can chime in. Your call.
I will ask one more question. You both have experience on the other side of the bench litigating some voting rights cases. So I was just wondering if you could each talk a little bit about what it's been like to go from litigating to hearing and deciding on some of these cases. And that will be our last question.
Yeah, I think Justice Earls and I both have had the experience of how much it matters when you are representing clients brave enough to step up and challenge a case in our judicial system. It matters that you have a judge who's willing to listen to the facts and deeply values the right to vote, hearing the facts and deciding the case. We're not advocates now, but that constitutional commitment is a thread through every element of our career. I think it's incredibly important to have, and I know this I thought this when I was an advocate and a litigator. I know even more deeply it's true now. It is so important to have people with deep civil rights experience on the bench. When we are the ultimate sort of bulwark against intrusions on constitutional rights and freedoms, having people who have fully seen the promise of those constitutional protections and how much work goes into ensuring that promise is delivered is important. So I was all on board for making sure we had professionally diverse benches, state and federal, before I was on the court. And now I am certain that the perspective that having experienced civil rights litigators on the bench really matters. I will also say, for folks who've done civil rights litigation, we were frequently underfunded and overworked. And so I think we bring a lens and an understanding of how hard it is to do the work of litigating constitutional cases, voting rights cases in our courts. And we need people who understand that to better address and improve upon places where access to justice is too closely linked to economic resources. It shouldn't be that the side with the most money wins in a case determining any fundamental right, but certainly not the fundamental right to vote. So that's my perspective on that.
Well, and I'll just add, so if the question is, should someone who's done a redistricting case be able to be a judge on a redistricting case? And certainly there have been motions filed saying that I should recuse myself from a redistricting case because I previously litigated those cases. I want to make two really important points about that. First of all, I was on the bench in 2019. Before the census, before the plans that were litigated that ultimately came before me were ever even drawn. So totally different redistricting plan. But secondly, and also I think something that people don't think about all that much, is that every single justice had some kind of career before they got on the bench. In this country, that's just what we do. We have lawyers who've had some kind of professional experience. Other countries actually do have people go straight from school to the bench. So in some sense, they are professional judges. But so no one seems to ever ask the question, should a prosecutor who previously, say for their entire career, prosecuted criminals, should they sit on a criminal case? We think that's perfectly fine. Should someone who did insurance defense for their entire career, should they sit on a tort case where someone is suing an insurance company? We think that's not a problem. Every justice comes to the bench with some kind of experience, and actually, as I think, and this is what Justice Riggs was saying, actually it's a plus, right? It is a plus that we have that background and experience. It is a plus that the court is diverse. We definitely need to have a variety of professional backgrounds, but we have to be generalists, right? One day we are hearing a complex business case, the next day it's a criminal case, the next day it's an employment case. So I think that it is vitally important that we're honest and clear about what our backgrounds have been. The voters can decide ultimately what kind of court they want, but I think that it is really important that people who have represented individuals across the state are the ones who are then sitting on the bench.
Great. Thank you both so much once again for joining this conversation today. And thank you so much to everyone who tuned in to listen to this incredible conversation. Please be sure to follow AFJ Action on social media to stay up to date on our future events. You can also sign up for AFJ Action's monthly State of Justice email newsletter, and we will drop a link to how to do that into the chat. And then additionally, we wanted to let you all know that our state courts team recently released our 2024 State of the State Supreme Courts report. You can find that report on the AFJ Action website, and we will also drop a link to that in the chat. And I just wanted to say once more, thank you so much to both Justice Earls and Justice Riggs for being here with us today at our inaugural Gavel event. This was just such a wonderful conversation. I really enjoyed hearing more about the incredibly important work that you do and how committed both of you are to carrying it out. So thank you so much once again. Thank you to all of our viewers for tuning in, and we will see you next time.
Thank you.